You are watching the LemonAid Podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hello and welcome to the LemonAid Podcast with lemon law expert Shalev Amar. I'm your host, John Clemence, and today we're peeling back the layers of an important topic for anyone navigating the lemon law world. So first of all, Shalev, it's great to have you back.
Thanks for having me again.
Yeah, absolutely. And today we're going to answer the question, is it too late to file a lemon law claim if my car is finally repaired? So I'm really interested in this one. So Shalev, from your experience, how often do manufacturers offer cash settlements like after a vehicle is repaired?
I would say if there's a substantial enough repair history, it's still pretty common. You know, we pre-screen our cases. So in the context of matters that we handle, at least 95% of the time, there will be an out-of-court offer. So, you know, if the vehicle is repaired, it might limit whether a lemon law presumption would apply. And there's some case law that requires continuing defects, but be that as it may, there's also other cases that say if you've had a substantial enough repair history, you should still be entitled to compensation. Because, you know, let's look at a ridiculous hypothetical. Let's say you've had 30 repairs for the vehicle's engine, and on number 31, they finally magically repair the vehicle. Well, I don't believe that erases the prior 30 times, all the inconvenience, all of the time that has to be spent to get the repairs. I don't think that just magically waves it away, like with a magic wand. So that's why in most circumstances, even if a vehicle is repaired, you know, the manufacturer might make arguments based on that, and it might affect the amount of money that they're willing to offer. But generally, if it's a valid case, if it's a substantial enough repair history, they'll still make a substantive offer.
And so why would they prefer repairing a vehicle and just paying you that money for the repair rather than replacing it or repurchasing the vehicle?
They don't necessarily pay the cost of repair. That's not how that works. Sometimes they try and argue the cost of repair. We argue that that's insufficient. Typically, when they offer cash compensation, it's based on diminution in value. What that means is you basically just didn't get what you paid for the vehicle. If the repair history you were going to experience with it and the defects were foreseeable at the time of sale, what should the vehicle really have cost? Typically, it would be less than what you paid for. And the reason why they'll offer cash compensation rather than a repurchase or replacement is it's just easier for the company to do administratively as far as just cutting a check rather than having to deal with the entire process of reacquiring the vehicle. It typically requires the cooperation of a local dealership, a third-party transfer agent to handle the transaction of returning the vehicle. Then typically the vehicle has to be tagged or labeled as a lemon and sold at auction for a loss. So oftentimes the company would prefer to just say, hey, we're sorry, and cut a check rather than deal with that whole process.
Yes, it sounds like it's just a whole other level of cost and hassle for them when they could just cut you a check and move on down the road.
Correct.
Okay. And so let's talk a little bit about some legal protections that you would have. So let's say that I have a vehicle, it's been in an accident, so it's finally repaired. What protections or compensation might I still be entitled to under a state's lemon law?
There's three main resolution options. One is a repurchase, and that's where they will basically do, it's called a lemon law buyback. They'll pay off any outstanding loan balance. If there's a loan, they'll refund the money paid towards the vehicle. That does not include things like insurance. We're talking about money spent towards the vehicle or its loan, minus what's called a usage fee or a usage offset. That's typically based on cents per mile. The more expensive the vehicle, the higher the cents per mile, and vice versa. The second option is a new vehicle replacement. It's the least common because there's the most to do administratively. That's where they'll replace the defective vehicle with a new vehicle, comparable new vehicle. As long as the price is the same or lower, then there's no charge. If the price is higher, you could still do that, but you typically would have to pay the sticker price difference. The third option is cash compensation. Those are the most common type of settlements. They're called cash and keep. It's like what it sounds. They give you cash money with keeping the vehicle. And so those are the three main options. So if the vehicle is repaired it might make it more likely that it would be a cash compensation settlement, but oftentimes the other two options are available as well, as long as the state lemon law is not timed out.
Okay, so talk to me about that. What would the time frame be for a lemon law? Just as and maybe take your state for example.
Well, it varies state by state. We operate in multiple states, so I can give you several state examples.
Yeah.
Typically, the range ends up being 1 to 2 years from the date of original delivery and purchase of a vehicle. And that means when it's first sold, not when you buy it. So it's typically 1 to 2 years and 12 to 24,000 miles. But there could be other variations. Some states, for example, have a 1-year lemon law period, but there's no mileage limitation. Other states will have, it just varies by state. But for example, in Arizona, it's 2 years, 24,000 miles is the lemon law period. In Utah, for example, it's a 1-year lemon law period, but no miles. And it appears to be a 4-year time limitation to bring a claim. In Arizona, you have 6 months to bring a claim once you hit either the 2 years or 24,000 miles, whichever comes first. There's other states like California where typically the entire warranty period is covered by the lemon law. So again, there's some variation between the states, but I'm not aware of a single state nationwide where the lemon law period is less than 1 year, unless the manufacturer's warranty is for less than a year. But that's very rare. I think that would only necessarily be the case for a new vehicle. If it's a motorcycle, some of their warranties are a shorter duration, but that's very, very rarely the case. So typically the lemon law period is at least 1 year.
Okay. And like you said, that's 1 year from the point which the car was sold, not necessarily to you. And then would that cover the mileage as well? It's mileage from the point when it was sold?
Correct.
Okay. So let's say that I'm coming to you, I'm a potential client, and I'm trying to learn about this to see if I have some kind of a case. What kind of repair history or documentation could I bring to you to make a strong case for my car?
Well, the best repair records are always the invoices from the repairing dealership. A couple names for these. They're called work orders or repair orders, but it's basically the document that shows the problem that you're bringing the vehicle in for, states the defect, whether it was confirmed as being covered by warranty or not, whether it's confirmed as actually occurring, and typically when repairs are done, what components were replaced, what was done to repair the vehicle, how long was it in the repair shop, the mileage in and the mileage out, showing any miles that were put on the vehicle, test driving it, and also the mileage when the vehicle was dropped off. We just mentioned that. What I was meaning to say was the date that the vehicle was dropped off and the date that it's picked up after the repairs are done.
Yeah, so basically just the full we want the full comprehensive picture to know exactly what happened, when, and who did it.
Correct. The number one piece of evidence in these types of cases is the vehicle's repair orders. Anybody can say anything, but you don't want to get into a he said, she said situation. You want the actual repair documents for these cases.
That totally makes sense. So let's talk about repairs for a moment. When you're talking about evaluating a potential lemon law claim, can you help us understand the difference between a one-time major repair versus multiple minor repairs?
Most state lemon laws have a substantiality requirement. And what that is it can't just be, like a cup holder or a door rattle to have lemon law coverage. It's got to be something more substantial, like engine, transmission, brakes, the vehicle's vibrating, the vehicle's hesitating upon acceleration, the vehicle's dying on you, the vehicle's not starting. Those are all obviously substantial. Sometimes you can have defects that are kind of more gray area. And so, for example, like if your entertainment system is not working, it doesn't mean that your vehicle doesn't function, but it is impairing your use of the vehicle, because it's pretty standard these days to have a functional stereo system or navigation system. So that's kind of more of a gray area where it can be argued either way. The way I look at it is the more substantial the defect and the repair, the less often it needs to occur to be able to potentially qualify as a lemon. In fact, in several states, like Oregon comes to mind, if you have a defect that is so substantial that it puts you at risk of death or substantial bodily injury, it only needs to happen once or twice. Where defects that are substantial but don't necessarily harm your life or put your life in jeopardy or your physical health in jeopardy, but they're still substantial, those typically need to happen, I would say, at least 3 times, at least 3 separate repairs. Also, as far as major repair, it could be that the repair is taking a long time. So let's say you're getting 1 repair for the transmission, but you're without your vehicle for a month and a half. Well, that's very major. You would qualify right there typically, even if it's just 1 repair, because you're without your vehicle for a month and a half. There's 2 main elements as far as proving whether your vehicle has been subject to an unreasonable repair history. One way is if you have a substantial defect or condition repaired too many times. The other way is if you have your vehicle repaired for too long. So that could be 1 repair, it could be cumulative, but it's just, basically unfair that you're paying for your vehicle and it's in the shop for a substantial amount of time. You're paying for something that you can't use. And oftentimes, even if you're provided a loaner or a rental, it's not even close to the caliber of vehicle that you're paying for. So, you're still obviously harmed by that type of situation.
Okay, so it sounds to me like there's financial considerations, perhaps. There's also time considerations and just honestly the hassle of being without your car for a period of time. Like all those things play into your evaluation?
Correct.
So what happens if someone comes to you and says, look, my car is running smoothly right now, but it wasn't in the past? How would you walk someone through that kind of a situation?
Well, here's the way I look at it. If the car ends up being properly repaired over time, that's wonderful. But the one thing in life that we can't ever get back is our time. And I'm sure there's almost no one out there that would prefer to be spending time at a dealership, being inconvenienced, missing time off work, school, family obligations, social stuff, because they're having to go back and forth to a dealer dealing with repairs. There's very few people who would prefer to do that over other things. And so, even if a vehicle is eventually repaired, that inconvenience factor still entitles people, in my opinion, would still entitle a consumer in that situation to be compensated. Because the one thing you can never get back in life is time. And so that obviously has value. And there's also the factor of just not getting what you paid for. If you're dealing with a defective vehicle, you bought new, you're really dealing with something that's like used and run down that should have cost you way less money.
Yeah. And I'm glad you brought up this idea that, time is valuable. And I'm really, it's good to hear an expert bring that up and mention that is really an important part of compensation. And so along those lines of compensation, if I'm a consumer, can I pursue compensation if I'm given a rental or a loaner vehicle, but it wasn't equivalent? We've sort of talked around this, but it's not equivalent to the one that I bought, and I've got this lesser vehicle on loan. Is there any compensation I can give for that?
Yeah, I believe compensation is still possible. Providing a loaner or rental is not a defense in most states. The only state that I'm aware of where that is a potential defense off the top of my head is Texas. Doesn't mean there's no other ones, but that's the only one that's the only state that comes to mind. Generally, that is not a defense to a claim. Now, it could be what's called mitigation of damages. Mitigation just is basically, to put it into English, a lessening of damages, I would say. So, if you're provided a loaner, you're obviously not as badly hurt as if you're paying out of pocket for a rental. And even if it's not your vehicle, it's still better than nothing. So I would say it could affect how much compensation you should get, but I don't think it completely prevents you from getting compensation.
I see. Yeah, that seems like a nuanced view that I can appreciate. And so finally, Shalev, what would you say to someone who's maybe hesitant to file a lemon law claim because they don't want to be difficult or they don't want to be seen as litigious. What would you tell someone in that situation?
Look, that's understandable. A lot of us, we have to deal with enough conflict and nonsense in our day-to-day life. We don't want to add to that. But here's the thing. It's just, as a consumer, you're doing what you're supposed to do. You're making the payments on your vehicle. You're getting the maintenance done. And so if it starts breaking down on you and can't be repaired properly under warranty because of defects in materials and workmanship, well, that's not fair to you. And that needs to be made right. So look, in a world where vehicle manufacturers would just proactively compensate people fairly, and I'm not saying something token like a few months of warranty extension or a few months of free maintenance, that in my mind is insufficient with a defective vehicle. And so it's not about being litigious or wanting to just fight just for the sake of fighting. It's just, again, if you didn't get what you paid for, you're basically being ripped off. In my mind, it's a type of financial harm that you're suffering. And so, you should want to stand up for yourself and be fairly compensated. Now, a common misconception that people have is if they pursue a lemon law claim, they're automatically filing a lawsuit and they're in court in front of a judge and jury. It's actually not like that at all. In fact, 95% of our cases settle out of court without any type of lawsuit.
Wow.
So there's no hearings, there's nothing like that to attend. What happens is our legal team negotiates a settlement on your behalf out of court. And typically, as far as the consumer, our clients, they have some phone calls with us. There's some emails back and forth. We have them sign some paperwork if the case settles, or we'll let them know if there's questions or arguments made by the other side. But typically, it's very rare for the out-of-court process that would take any more than half an hour of our client's time. It's very rare that would be any more than that because, again, there's no court hearings or anything like that to attend for 95% of our cases that do settle out of court. And so just by bringing a claim doesn't mean that you're going to be filing a lawsuit. You could be part of the 5% that does, but that's a small percentage. That's about 1 out of 20.
Yeah, I think that's a great high note to kind of wrap up on, to a little bit of hope for people that, hey, you don't necessarily have to go, before a judge. These guys can take care of it for you. So that's wonderful. So again, to our listeners, thanks for joining us on the LemonAid Podcast with lemon law expert Shalev Amar. Please like and subscribe to our channel and leave us a review. And Shalev, last question, and we'll end on this. How can people get in touch with you?
Well, we operate in several states. So as far as our phone number, it's our 866 number is 1-866-904-2627. And we have multiple websites in multiple states. I would say if you're in Arizona, it's ArizonaLemonLawAdvocates.com. If you're in Nevada, it's NevadaLemonLaw.info. If it is Utah, Colorado, Oregon, or Washington, then it's all LemonLawAdvocates.com. Your state, and then LemonLawAdvocates.com, like Washington, LemonLawAdvocates.com, Colorado, LemonLawAdvocates.com. And in California, it's CaliforniaLemonLawAdvocate.com with an S. And we're in process with Missouri and New Mexico. So by the time you're listening to this or watching this, we may be up in those states, and that would be the LemonLawAdvocates.com. So it'll be New Mexico, LemonLawAdvocates.com, and Minnesota, LemonLawAdvocates.com.
All right. Well, if you're listening, I encourage you to go check those out. And with that, hope you have a great day, and we'll see you next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.